The next case before us is HMVAL et al. We have Brian Murray, I believe, will be representing the appellant in this matter.
That's correct, Your
correct?
Honor. Yes, Your Honor.
And then we have 3 appellees represented here today, and I believe you all have decided about splitting your time.
Yes,
Is that
Your
correct?
Honor.
Yes, Your Honor.
Okay, just to go over it, each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know because I will be keeping track of the time. The arguments are being recorded, so please keep your voices up. You should not use the names of children or minors or victims during your argument. You can refer to them by initials or by terms like the child. The judges, of course, have read your briefs and are ready to proceed. I'll begin by asking the appellant whether he would like to reserve time for rebuttal.
Your Honor, I would respectfully request to reserve 5 minutes for my rebuttal.
Thank you. And then with respect to the appellees, you will just be passing off the time on your own and keeping track of the time that you utilize. Is that acceptable?
Yes, Your Honor.
Yes, Your Honor.
Thank you. Okay, then you may proceed when you are ready, Mr. Murray.
Thank you, Your Honors. For the past year, my client has been defamed, bullied, and harassed. When he has sought relief from the Avon School District, he's been denied. When he sought relief from the Avon Police Department, he's been denied. And when he sought relief from the trial court, he's been denied in his ability to try to get these other students to stop defaming him and bullying him. The trial court's judgment denying his request for a hearing on his preliminary injunction, I think, is chilling. I know some of these allegations are pretty sensitive due to the nature of the sexual assault, but there was more that was being said about my client than just these allegations of sexual assault. There were students that were posting things on the internet, websites, saying that my client likes men, that he's an anal lover. And to say that my client cannot have a hearing on a preliminary injunction or to have preliminary injunctive relief granted that would prohibit those students from continuing to post things like that about him until after a jury trial has occurred, where a jury trial has determined that my client does not love anal sex and is not bisexual or gay, I think is ludicrous, especially as long as it would take for my client to be able to get a jury trial in a case like this. It's not quick relief. And he was a junior in high school when this happened. He's now into his senior year. Things like this were posted on the internet. He's a high school athlete. He finished in the top 10 in track and field for the state of Ohio. He's got colleges looking at him. This shouldn't be something that's taken lightly. While I understand our First Amendment rights and protections are something that we all hold dear, defamatory speech is not unprotected speech. And I have a hard time believing that anybody would think that those initial statements and website postings saying that he's an anal lover, that he likes men, is something that we would have any difficulty proving is defamatory and not true. And to have to wait because it involves speech is ridiculous. And if we look at it from that perspective, and then we move over to the more sensitive allegations involving these false allegations of sexual assault, my client's done everything he possibly can to try to vindicate and prove to everybody that these allegations are not true. I understand polygraph tests, aren't considered admissible evidence. He went out right away. He took a polygraph test. He took an ocular eye detect test and passed with 99.2% reliability that the one juvenile he never had sex with and the other one was completely consensual. The school district dismissed the Title IX claims that were filed against him. But the bullying hasn't stopped, and it's gotten worse, and it continues to escalate. I think that the decision to not hold a preliminary injunction on this has only enabled these students and sent a message that, hey, you can continue to do this. When my client would go out over the summer be walking around in public. People would yell out that he's a rapist. He would be with students from other schools. People would walk up and say, you know, he's a rapist. When his locker at school, his football locker, people dump garbage into it repeatedly. People put change in his locker this year. He gets no relief. Somebody ripped off his car mirror, hit the mirror off of his car in the school parking lot a few months ago. He walks up to the Avon police officer that does school security. Sorry, you know, we don't have the time to go through the surveillance video to try to do that. He goes to church with his parents at Holy Trinity. What happens when they come out? Somebody's keyed up the whole side of his car.
Counsel, let me just ask, redirecting your attention back to your comments regarding the polygraph test. Was that admitted into evidence?
It's not been admitted into evidence. It was attached to, I'm pretty sure it was attached to our amended complaints. I know that some of the defendants had filed motions eliminated to try to exclude it. I don't recall if there was a court ruling on that yet due to the stay that was requested. And I think that's kind of ironic too, as it relates to the stay. The defendants request a stay of these proceedings pending the criminal investigation. That gets granted. My client requests a stay of these students defaming him, and that gets denied because it involves speech. And you have to have a jury trial on whether or not these allegations are defamatory before you're
What
entitled.
evidence was presented in regard to the criminal investigation, if anything?
There wasn't any evidence presented. This proceeding was halted pretty quickly due to the litigation over whether or not we were entitled to a motion for a preliminary injunction. The law director for the city of Avon had filed motions to quash the subpoenas that I had issued for the preliminary injunction. And in his motion, he had indicated the criminal investigation was about conduct that had occurred on or after February 11th, 2022. And that my client's cell phone had been seized in March of 2022 by the police. That was the initial response from the law director for the city of Avon. I don't think there was any mention in there about these allegations, my client being investigated for sexual assaults, but that's been, brought up by some of the attorneys for the defendants. I've reached out to the prosecutor's office. I've been reaching out to the detectives about where the investigation stands, what exactly is being investigated, and haven't been able to get any clarity on that. But everybody's been provided with copies of the polygraph and ocular eye detect test. The school, the police department, the prosecutor's office, defense counsel, and the trial court. And you're right, I believe the trial court abused its discretion and not giving my client the opportunity to have a preliminary injunction hearing on these issues. I also think that the trial court abused its discretion in believing that it had to wait for a jury trial before it could issue any type of injunctive relief on behalf of my client. But by the time you get a jury trial, the damage is done to my client. And especially when you're looking at this type of a case, we're involving high school students. I mean, the ability of these high school students to be able to reimburse my client financially for the emotional harm, for the damages that he's sustained, is highly unlikely. And the damage that he's going to face when it comes to his college applications, possibly trying to get a college scholarship for athletics, when these allegations just being blasted all over the internet on social media sites, where you got one of these students has hundreds of followers on her TikTok site where she was putting up these allegations, and some of her videos have been viewed thousands of times. You can't undo, you can't give him back the last year and a half of high school that was ripped away from him by these students who decided to do this. And it doesn't stop. It's continued to go on. Even up until now, it goes on. The student who walked into his classroom calling him a rapist last year in front of the class, who he didn't even know, now sits across from him at the cafeteria table and stares at him at lunch. And everybody just thinks it's okay, except for him and his parents. And it's outrageous what's going on. People are throwing packs of hot dogs in his parents' yard with forks in it because they think it's okay. The bullying and the intimidation and the harassment needs to stop. And it all started with these defamatory allegations against him. And until there's some form of relief, it's not going to end. And I think the court had the ability to proceed with the hearing. I think the court had the ability and the authority to issue a preliminary injunction, to refrain the speech. And I think the trial court erred in not giving him the hearing and basing its decision on its belief that it needed to have a jury trial first, and for a jury to determine whether these allegations by these students were defamatory. So I would respectfully ask this honorable court to reverse the trial court's decision and to remand it with instructions to proceed forthwith with the preliminary hearing.
Mr. Murray, you will have the full 5 minutes for your rebuttal.
Thank you.
Thank you. The appellees may proceed.
Thank you, Your Honor. My name is Robin Kanickis and I represent AW. I'll be going first for the appellees, and the focus of my argument will focus on the threshold issue, which is whether this court has jurisdiction on a final appealable order. And on behalf of all appellees, we ask you to find that you do not have jurisdiction, that this is not a final appealable order, and to send it back to the trial court. I think I laid out in the brief on behalf of all appellees a pretty clear framework that says the 9th District Court of Appeals does not support that this is a final appealable order, based on the fact that it does involve free speech rights. The trial court was very thorough in its opinion in finding that based on Ohio Supreme Court's precedent from O'Brien to Bay, that there has to be a judicial determination on the merits before it can determine whether to issue a prior restraint on speech. It has to be very tailored in terms of what it would find and what it would restrain. Because, for example, one of the students is alleged to have said yup. Well, under what conditions would the court put on it to say you can't use the phrase yup? It's a very generic phrase. Even my client, who's alleged to have said he literally sexually assaults somebody, she's responding to a question. I mean, that's a fair response in an appropriate circumstance. So the court would have a long procedure to go through before it could determine what type of restraint to put on. And that's, again, after a jury, as all parties have pleaded, a jury trial finds factually that their defamation occurred. Wire, let me see, Catherine Collections, those are all decisions from this court saying that there has to be a final determination, or I'm sorry, that permanent injunctions are not generally final appealable orders. In this case, although the decision to deny the preliminary injunction is final, it doesn't preclude the plaintiff from getting final relief at the permanent injunction. The trial court specifically contemplated that the parties would conduct discovery and have another hearing, again, where the finder of fact, the jury, would determine whether defamation occurred. So as the court did say in, Catherine's Collections, I wrote this down and now I can't find it. The heart of the underlying litigation is the words defamation and the speech. Once that's decided, then the client or then the plaintiff would have the opportunity to move forward with the final order from the court and whether it's defamation. So essentially he has a final meaningful remedy available to him at final judgment, in which case he actually has to prove that there was defamation. Kind of going back, there was a question, what happened to the motion in limine regarding the polygraph? And the court decided to hold that in abeyance because, and I believe that is part of the court's order from the 31st. No, I take that back, it comes later. Interestingly enough, in the court's later order, the parties also briefed the issue whether during a second amended complaint, the plaintiff could continue to plead a request for preliminary injunctive relief. And this is what they wrote to the court. The Honorable Court's prior decision to deny plaintiff's motion for injunctive relief does not prohibit plaintiff from subsequently filing an amended complaint that continues to request preliminary injunctive relief as one of his prayers for relief. Because this Honorable Court's prior decision is an interlocutory decision that it can reconsider at any time before the entry of final judgment. A preliminary injunction is a provisional remedy that is considered interlocutory, tentative, and impertinent in nature. And he cites in re estate of Reinhard, R-E-I-N-H-A-R-D from the 12th district, citing Wells Fargo Insurance, USA Services, Gingrich, also out of the 12th District. A court may reconsider and reverse an interlocutory decision before entry of final judgment, either sua sponte or upon motion, citing RRL Holding Company of Ohio, LLC versus Stewart from the 10th District, and also citing Alternative Unlimited Special Inc. from Ohio Department of Education, the 10th District. Reconsideration of interlocutory decisions is a matter within the judge's sound discretion. So apparently at the trial court level, plaintiff felt very strongly that the decision on the preliminary injunctive relief was something that the court could reconsider at any time. And I think it's important to note that, in plaintiff's opening or appellant's opening statement, he's bringing up a lot of allegations that are simply not part of the trial court record. What he's telling this court are allegations of things that have happened well after filing suit, well after we've been engaged in pleadings, and those are simply not part of the trial court's record for consideration. Moreover, when he talks about defendants filing a stay in the trial court, there was no objection from plaintiffs. There was no brief in opposition to the plaintiffs. So this idea of waiting for a jury trial, he had every opportunity to file his brief in opposition and demand that the trial court proceed at full force ahead. Of course, it would have presented the option for all the parties to depose his client, cross-examine him, and that was a risk that he had to weigh and whether to proceed while there's a pending criminal investigation. Candidly, I think the trial court saw fit to try to protect the young man's rights in either a delinquency proceeding or if he's determined to be tried as an adult for the alleged sexual abuse. One of the things plaintiff raises is whether the trial court was required.
Counsel, let me stop you because I'm still getting confused too with the record and so forth.
Yes, ma'am.
Really, when you're talking about a record, we don't have any hearings or anything, so it's just allegations being made and what's in the pleadings and the responses and so forth.
Yes, Your Honor. The trial court ruled on the pleadings, the motions that were available to it.
And when you say, the trial court was probably protecting his interest due to a criminal charge or whatever, there's nothing in the record about a criminal charge being made or instituted.
If I said criminal charge, I apologize. I misspoke. I think part of what is in the court's journal entry is that there's no object or nobody disagrees that there's a pending criminal investigation.
Okay. All right. Thank you.
You're welcome. Thank you, Your Honor. Regarding whether the trial court, well, let me go back. What plaintiff appellant raised in his brief on jurisdiction was the idea of the 10th district during the COVID pandemic deciding a case based on benefits. In that case, the realtors were suing Governor DeWine, saying that he had to continue benefits to participants in the CARES Act, which was going to allow those participants to continue to collect $300 a week while they were unemployed. And by the federal statute, that was supposed to go until September of 2021, whereas Governor DeWine signed an order that it would end prior to that, at which point a lawsuit instigated. And what the 10th district really looked at was that when it involves a benefit by statute, like Medicaid, unemployment, where there's going to be finite goods or funds available, that is more of a special remedy because it dealt with somebody being able to subsist in their life, their rent, their utilities, their food. That's not what this situation is. The only thing the plaintiff brings up is that there's something special about his high school year of senior year of high school. And respectfully, that doesn't rise up to the level of people being able to eat and keep a roof over their head and keep the heat on and utilities going. And I don't think that situation applies to this one. So that I think that the court should disregard what the 10th district did. That case was taken up on appeal to the Ohio Supreme Court in, I believe it was November of 2022. The Ohio Supreme Court ultimately decided the issue was moot because the CARES Act did end in September 2021. There was nothing left for it to decide at that point. So yes, the court did allow jurisdiction over the injunctive relief, but there is history that when it involves a specific statutory benefit, that's when it's allowed. And that is different than the case law regarding defamation that says that you have to have a final order or final judicial determination on the merits that defamation occurred. And unless there's any questions, I'll give time to the other appellees.
One of
I
you would
cannot
like to
hear-
proceed?
Okay, Judge Sutton, I cannot hear you. Sorry, I can hear you now.
Oh, that's okay.
Okay, Jonathan, if it's okay, we'll stick with our plan. Your Honors, Michael Maloney for appellee BK. I show I'm starting at 11:57, give or take. I would like to quickly and if possible clearly summarize the issues raised by Mr. Murray's client, not us, because he hasn't talked about them. We heard about hot dogs being thrown in cafeterias. I have no idea what that has to do with this appeal. It's not in any pleading. There is no evidence of record, Judge Carr. No evidence has been taken. The orders and rulings by the trial court were all based upon pleadings, and correctly so. The appellant has taken the position that he's been bullied, Your Honors, and never mentioned that he's under criminal investigation. That is a specific finding by the trial court. It is in the trial court's order denying the relief sought by the plaintiff in this case. It is not disputed. It is an agreed to fact, one of the few. To characterize this as his client is a victim is astounding and offensive. My client posted nothing. There's not an allegation that BK posted anything, texted anything to his client, posted anything on social media. The two statements that she's alleged to have made are both privileged. And let me clarify, the Title IX investigation was not dismissed. There was no jurisdiction. The investigators determined after they contacted my client, she did not contact them. When they contacted my client, it was determined that the crime did not occur on school premises and did not occur in connection with any school activities. Mr. Murray neglected to state that. That is the reason that investigation was terminated. Had nothing to do with the merits of the allegations. The other statements my client made were to the police. They are completely privileged, and those are pending matters as we speak. So the bullying alleged occurs during the course of an investigation of a rape against the plaintiff, and oddly, he wants to have a hearing so he can depose the victims outside of the parameters of criminal discovery. Judge, Mr. Murray explained nothing about the elements, the standard of proof, what he was expected to show in the trial level, and those are what you know them to be: a substantial likelihood of success on the merits. The merits of his client's claim against BK is that she's a liar, Your Honors. That is the claim in this case below, that my client is a liar. The trial court found that there was not a substantial likelihood, having read Mr. Murray's 92-paragraph complaint, the trial court made a judgment it's entitled to make and decided there was not a substantial likelihood that the plaintiff would succeed in proving that my client was a liar about being raped. The second, it's the fourth element of four that the plaintiff had to show to succeed below, but I'll skip to it. I would like to hear Mr. Murray explain what public interest is served by subjecting victims of sexual offenses to cross-examination outside the parameters of the criminal case. I'd like to hear how that's in the public interest. I suggest to this court it is not. The trial court found it was not, and correctly found it was not in the public interest to have these girls, high school age victims of sexual assaults, subjected to cross-examination in a civil proceeding in which they were being called liars.
Counsel, we don't have much time left, but
Okay.
I should have, no, you're fine. I just wanted to say something or ask a question. In regard to the present climate we're in, I know this involves possibly criminal sexual allegations, misconduct and so forth. But we also have the competing interest, don't we now, in our society? It's a TikTok generation. And if you say it on TikTok, it's accurate. And we have kids that are killing themselves from being bullied. So how do we weigh all that in when we're talking about when we're going in regard to a final appeal board with a preliminary injunction and regarding whether or not it is something that can be remedied after final order?
We do, Your Honor, we do exactly what Ohio law allows and what the trial court did. The trial court carefully considered exactly what you've described. We cannot cure most of what you described, and we certainly can't cure it legally. That is a problem that left port years ago. I'm 61. I won't pretend to understand how and when it started. I hate to say to you, as a non-legal matter, there is no cure to this. Bulletin, that wasn't the trial court's responsibility. The trial court was to follow the law on preliminary injunctions, and the trial court did so. Incidentally, nothing has happened since February of 2022. Nothing. I have no idea what this discussion was about cafeterias. Nothing's been posted. Nothing's on social media. No one has contacted the plaintiff. Nothing has happened since the time this was all filed. If I may, Jonathan, I apologize. I'll just wrap up by saying my client has argued the law from executive management and Danziger. Those are the more recent decisions that plainly and clearly set out that the trial court has discretion and that the rule tends to require a hearing if the injunctive relief is going to be granted. Absolutely plainly spells out that where the injunctive relief is being denied, there is no requirement for a hearing. Mr. Murray knows that. This Court of Appeals knows that. That's the law. The decisions.
Thank you, Mr. Maloney.
Okay.
Your time actually
Sorry.
is expired, and Mr. Angarola, the appellees have used up all of their time. If you would like to say one statement, I can extend the courtesy to Mr. Murray as well.
Thank you. Sorry, everybody.
Yes, I just want to point out and dovetail with Mr. Maloney, the Danziger case, which squarely addressed the appellant's argument that a hearing was required on his motion for preliminary injunction. The Danziger, the 6th district.
Okay, I can't allow you to go into it too much. I just wanted to give you an opportunity to make a quick statement, and we have to move on.
Okay, the quick statement is when a plaintiff does not demonstrate a substantial likelihood of success on the merits, the trial court does not abuse its discretion in denying the motion without a hearing. That's what the Danziger opinion is that holds, and I agree with Mr. Maloney on that point. Thank you.
Thank you very much. Mr. Murray, you have certainly your full time for rebuttal, and we will extend you a little bit of courtesy should you need that extra time.
Yes, Your Honor. Thank you. Your Honor, first off, as to whether I was able to establish that there would be a substantial likelihood on the merits, I think we would have been able to establish that. Again, the polygraph test with the ocular eye detect test, those two tests in combination of one another, and it's an issue of first impression in Ohio as to whether or not those two tests combined satisfy the evidentiary standards to be admitted. And again, the reliability was 99.2%, according to Bill Evans, who's a widely regarded polygraph expert who's used by law enforcement, who's used by the various prosecutors' offices within the 9th District who rely upon his test results in determining whether or not to prosecute individuals and whether to believe witnesses are being truthful in cases. And to say that we would not have been able to establish a substantial likelihood on the merits on that issue, I respectfully disagree with the defendants as to what the public interest is and what would the public interest favor in a case like this. I think the public interest would favor these students not posting things on social media, and whether it comes by an injunction that's ordered by the court or whether it's something the defendants would agree to. There's nothing that prohibits the defendants from entering into a agreed upon injunction and agree not to be posting any further things about my client on the internet, and to take down what they've posted and to stop bullying and harassing him at school. There's nothing that would have prevented them to do that and just let the criminal investigation play out. They could have easily done that instead of wanting to go forward with a preliminary hearing. It takes two sides on that issue. So it wasn't just about trying to get these individuals, these alleged victims, up on a witness stand to cross-examine. The goal was to stop this from happening. These individuals weren't sued for going to the police. They weren't sued for going to the school. They were sued for what they were doing by posting stuff on the internet and harassing and bullying my client. My client had no other remedy available to him to try to get this to stop. And while the defendants keep saying that my client would have a meaningful and effective remedy after a jury trial in this matter, what is that remedy? I don't think that there is one. We're talking about high school students. They're not going to be able to pay a civil judgment that we render against them if we're successful. And it's more than just about being a senior in high school or a junior in high school. He's got a right to a public education. And you have students that are walking into his classrooms, calling him a rapist in front of the class. He's got to walk at certain times down hallways throughout the school. And he continues to be bullied and harassed to this day. And Mr. Maloney's claims that nothing's happened since February is not true. And the reason why I brought up what's been going on over the past year was to demonstrate the point that my client doesn't have a meaningful and effective remedy after final judgment. And that an injunction, if it would have been issued, would have likely stopped everything that's been going on for the past 9 months. And as to the argument that it's going to be difficult to restrain speech that involves a statement like yup, it's not about yup. Yup is republishing and reaffirming the statements that my client sexually assaulted these individuals, as the defendants would have everybody in the public believe. That's what yup's doing. It's not just merely saying yup. It's that person ratifying what's been said about my client. It's ratifying the defamation. And I agree, the bullying of students and the effects it has on students going forward is significant. We see that in the media every day. And I'm not saying that a court always has to have a motion hearing on a request for a preliminary injunction, but with Executive Management Services, Inc., with that case, I even cited that case. The court has to look at it on a case-by-case basis in determining whether it's warranted. And in this case, it was warranted. And I was respectfully asked the Honorable Court to find that there was jurisdiction to hear the appeal in this matter. My client, there's not a meaningful remedy for him once the preliminary injunction was denied. And I would ask this Honorable Court to find that under the circumstances of this particular case, the trial court abused its discretion in denying the motion for preliminary injunction without a hearing, and also abused its discretion in finding that my client would have to wait until after jury trials occurred and until after a jury's made a finding that the speech was defamatory before he's entitled to any form of injunctive relief. Thank you.
Any questions? Okay, thank you all for your presentations. The court will take the matter under advisement and issue an opinion in due course. That decision will be mailed to you by the clerk of courts on the day that it is released, and the opinions will also be posted on the Ohio Supreme Court website. Thank you again.
Thank you, Your Honor.